Hi, everyone. I think we're going to get started with our next panel. The title of this panel is Leveraging Strategic Communications in International Arbitration. My name is Ann Erda, and I'm the editor-in-chief of Law 360. We are a daily legal news wire, about 200 journalists based in New York, DC, London, LA. We have an international arbitration wire that hopefully many of you read. So I'm delighted to be here today, and I'll be kind of guiding our conversation. But we have an all-star panel for you, and I'm going to go ahead and introduce our speakers now. So Jennifer Haworth McCandless is a partner at Sidley Austin, where she serves as counsel in complex international arbitration cases with a focus on investment treaty arbitration. She has advised and represented private and sovereign clients in proceedings before ICSID and its additional facility, the ICC, and other arbitral institutions. Jennifer is consistently recognized for her arbitration work. In the most recent edition of the Legal 500, Jennifer is praised as outstanding and never tires of responding to questions. That bodes well for this panel, so welcome, Jennifer. Then we have Andres Romero, who is the supervising counsel with Chevron Corporation's Enterprise Litigation Group at the company's headquarters in California. He focuses on complex, high-stakes, transactional, and cross-border litigation and international arbitration. Mr. Romero manages Chevron's worldwide litigation arising from a fraudulent $9.5 billion Ecuadorian judgment against the company for alleged environmental pollution in Ecuador, in the matter that has been dubbed the world's most intensely litigated case by American lawyer and the legal fraud of the century by the Wall Street Journal. The case involves proceedings in the US, Canada, Argentina, Ecuador, the Netherlands, and Gibraltar. Over his 20-year tenure with Chevron, Mr. Romero has handled transactional matters, negotiations, litigation, and arbitration in 26 countries and has worked and lived in the US, the UK, Kazakhstan, and Latin America. Tom Sikora is the senior counsel for ExxonMobil Corporation. Tom manages international commercial and investment arbitration for ExxonMobil. Prior to joining Exxon, he spent 10 years at El Paso Corporation, managing the company's international arbitration and complex litigation. Tom initially practiced international arbitration of energy, construction, and insurance disputes at Vincent & Elkins in Houston. He is a member of ICC Commission on Arbitration and the Executive Committee of the Institute for Transnational Arbitration, where he serves as the chair of the Strategic Planning Committee. Tom also serves as a co-chair of the Energy Arbitrators List. Welcome, Tom. And then finally, we have Patrick Pearsall, who is the chair of Jenner & Block's Public International Law Practice. He has been recognized as a leader in the field of international disputes by his peers in Legal 500 and Who's Who Legal. Mr. Pearsall served in the U.S. State Department from 2009 to 2017 and was the chief of investment arbitration from 2015 onward. He has arbitrated claims involving billions of dollars on behalf of the United States, other sovereign states, and private investors in both commercial arbitration and investment arbitration. He is a trusted advisor to governments and private entities and is regularly called upon to provide strategic counsel before a dispute arises. Welcome. We're delighted to have you all here. So we were talking earlier about what strategic communication and international arbitration really means. And I think what's interesting about this panel is that we're all going to have pretty different perspectives on it. I certainly have one as a journalist, and I think the lawyers to my left will have a very different perspective than I have. So, we're looking forward to a lively debate today, and we'll, of course, save time for questions at the end. If something comes up during the course of the conversation, let us know, but in general, we're going to hold them to the end. So we're going to start by talking about kind of the approach that specifically Andres and you, Tom, take with your individual companies. So, Andres, maybe you can start us off. Tell us about your media approach to high-profile cases and why you think that's effective for your company. Because it seems like you guys are really willing to engage in a way that many are not.
And that has been a philosophy or an approach that has evolved over time. I've been 20 years with the company, and 20 years ago, the orthodox view was the standard no comments approach with anything relating to arbitration or litigation. Over time, we learned that there's, even though that's perceived as the low risk approach, it is really not exempt of risk and cost. And what happens is that louder voices fill that void. And those are voices that may not be constrained by facts, by the law, in the way you would be. Therefore, there's going to be a potential reputational harm to the company if your position is going to be, we will wait for the final arbitral award or the final court decision to vindicate our position, show that we're right and the allegations are meritless. Therefore, of course, each case calls for its own approach. It's different if we had, say, a dispute with Exxon and an explicit agreement that is going to be resolved privately and confidentially, and that's going to be an entirely different set of circumstances. But when you're engaging with opponents that are vocal in the media and are trying to tarnish the reputation of the company, leaving that unanswered is going to cause harm to the company. And it's not enough, we've learned, to win in court. We want to win in court, we're going to win in court, we're going to win in our arbitrations, but we're also going to win in the court of public opinion. And we need to achieve those, otherwise the business objectives of the company are not going to be achieved. And with that in mind, I will suggest to you 3 different principles that, in my mind, guide an appropriate response in these circumstances. The first one is the no comments approach is no longer acceptable, and that requires a lot of preparation ahead of time. It requires a lot of discipline, developing messages and talking points, and being proactive, engaging with communication specialists, and who are an important part of the team. Lawyers believe that we're great communicators. Communications specialists tell us we're not. We're boring, we're verbose, we are too pedantic and not effective communicators. And I'm talking about general business media, not necessarily legal publications, but things that are going to hit the wire and go to the general business media. So engage with communication specialists, develop good talking points and messages, develop your objectives and strategies, and implement it, which leads me to the second principle, which is try to be strategic, not tactical in your response. By that I mean you cannot play whack-a-mole trying to respond to absolutely everything that's said against your client, against your company. Is going to be impossible. The amount of frivolous claims and false allegations and against large companies is just too vast to try to do that. So develop your strategy. What are your objectives, your target audience, and your talking points? Stick to those despite of whatever older falsehood may be thrown at your client or the company as you are implementing that. And the last point is becoming the reliable, trusted source of information. And that means, despite of what your opponents do, try to avoid hyperbole, inflammatory language, embellishment, be very candid, become the repository of information to journalists. If they want to see pieces of evidence, make sure that whatever whatever assertions are made are supported by evidence, just as carefully crafted as if they were court filings or arbitration filings. Share the underlying evidence with the journalists if they're interested in it. If they're asking even for evidence or facts that are unfavorable, be candid about them, disclose them. It's better it comes from you because you can provide the context and explain what it really means and why, in your mind, it doesn't change the outcome, rather than trying to avoid information that you dislike. So again, be proactive, avoid no comments, be responsive to the media, be strategic in your approach, and become the reliable source of information.
I mean, as a member of the media, that sounds very good to me. But Tom, I'm going to guess that you guys have a very different take on how you should engage.
That's right. Let me say thank you to the organizers first for having me. It's an honor to be here. And just one caveat, I'm speaking as Tom Sikora, not as, the board of ExxonMobil Corporation. Chevron's,
I'll piggyback on that and make the same comment retroactively.
Chevron has a very successful approach, but I would say Chevron is an extremely sophisticated player, and their approach tends to be fairly unique. With respect to the investors, and I've worked for two and represented many more in private practice, while generally speaking, investors almost always have a media plan with well-agreed and planned responses and talking points. When it comes to material international disputes, most often their response is, we don't comment on pending arbitration or pending litigation. Why is that? They're primarily interested in having the story go away because, generally speaking, international investors believe that they really can't prevail in the court of public opinion of the host state, and so they have nothing to gain in engaging in a PR fight. If they put a story out, there may be 20 stories coming back at them, criticizing them, making them out to be a greedy, dishonest foreign company that's trying to take advantage of the good people of the local state. And you have to realize that in many of those places, God has a sense of humor. There's no oil and gas production in Switzerland. The state often controls the media or has a disproportionate amount of influence over the media. And so the state's message is very powerful. And rightly or wrongly, in a place where a lot of people are poor and suffering and there's economic crisis, these messages resonate with the population. And so particularly at a time of crisis when an investor is suing for hundreds of millions of dollars or billions of dollars, that's just not a PR fight that an investor is going to win. And one more important point, which is in places where we still do business, in places in which, despite a dispute, we have to maintain some relationship with the government, nothing good comes out of publicly attacking the government. Again, it's not a fight we can win in public opinion, but we are vastly better off quietly engaging with the government and trying to reach some private settlement or resolution. And if that fails, coming to ICSID and trying to get it resolved there without publicly attacking the government. It's a place we still have to do business. Those are people that we still have to maintain our relationship with. One exception, of course, is if the reputation of the company is attacked in certain situations, pollution, global warming, because the reputation of international investors, particularly large infrastructure and energy companies, is so important to them that I think we will make an exception and we will push back merely because our reputation is at stake and that reputation has to be protected. But that's the vast minority of the cases.
Mm-hmm, mm-hmm. Yeah, that was one of my questions, whether you were willing to let that kind of misinformation be out there. But so Patrick, I'm going to turn it over to you now. So obviously the government probably has an entirely different approach to media in these cases. And what is their objective? You spent a long time there, a very storied career there. What do you think that their goal is in terms of, their relationship with these journalists in some of these instances?
Well, thanks. Well, it's a hard question because there is no, of course, one goal that any government has in a situation like this. I mean, I think it's important to remember that governments are not the same across the world, and each government is different. But if you were to try to distill some things that are uniform among them, I think the first thing that you could say is that governments have conflicting interests in these cases. They sit within the investor-state dispute settlement system in multiple roles, right? So they sit as what I call the ISDS trinity. They're the lawgivers because they create these treaties, right? And they have obligations between states on that. They are respondents often in these disputes, and then they're the protectors of their investors abroad, or they're trying to attract foreign investment. So those three roles result in a sometimes divergent message in a case like this. And it diverges on the immediate impact of who they're even speaking to. So, at any one time, a state would need to be speaking to its domestic audience, including national champions who are exporting abroad. It would need to be speaking to foreign investors, right, to maintain its investment climate. And it would also need to be speaking to other governments, because it has obligations within a public international law framework, which is treaty-based. And below that, there's also a question of who is going to receive the information from the state, right? So mass media outlets, but also now social media, trade press. I mean, these are different access points that a state often is not sophisticated enough to enter, and then can lose the narrative very quickly. States also have special challenges. And the first challenge is probably the most obvious, and it's one of the reasons why often a state will adopt the position like the United States, which is that we don't comment on ongoing arbitration. And that is when a state speaks, it's the state speaking. And a speech act in these contexts, as everyone in this audience knows, can form the basis of subsequent liability. And when the state speaks, it's a state speaking, and it involves often attribution, and that's a very significant exposure. The other special challenges is for the United States, for example, when a case hits, often you don't get notice. If you're lucky enough, they give you 24 hours notice. And embassies, their job is to react, and they want to react around the world. And getting to those embassies quickly and telling them not to speak is difficult. That's one thing that a state struggles with. The second thing is you're talking about political actors, and restraining political actors it's a nearly impossible task. We do our best, but it's very difficult to tell the ambassador to Canada that they can't speak on this if it's going to hit the front page of the Globe and Mail the next day. That's their job. I work for the president, not for you, right? So that's a hard thing. And then finally, the media apparatus for a state, at least a sophisticated state like the United States, is so well developed that it's like a Ferrari engine that you're only asking it to go 5 miles an hour. It wants to go. It's got all of its press officers. It's got the press cone. I mean, this is what I trained for, and it's horses that want to go. And restraining that is a special difficulty for counsel. So all of this boils down to saying there is no state perspective. We're pluralist, conflicting entities generally. And it's, I think, the reason why most states adopt the policy of across the board, everyone knows we don't comment on ongoing litigation, because it's really difficult to manage all of that morass in a way that nonetheless protects you for the subsequent litigation.
Mm-hmm. Can I just chime in? Only because
Absolutely.
We represent both states and investors. So, I mean, I agree entirely with what Patrick is saying with respect to it's difficult to manage. But what I find more often than not, I think, is that governments feel a need to say something because their reputation is at stake and they want to say something in response. I think what's important as counsel trying to advise in that context is to make sure that if something is going to be said, if they feel compelled and a need to say something, that it's consistent. This is a way to address the issue of not creating more liability, right? It's consistent with the message that they are saying in the defense of the case. So that's, I think, a really important thing, because I really think it's very difficult to to not be able to say something as a state in response to claims that are brought against the state. Nevertheless, you can still say something. You have a defense, so you don't necessarily have to go into great detail, but at a very 30,000 foot level, you can make a comment that is consistent with the message of the case, which is a way to both address the needs of constituents and also make sure you're not damaging your ongoing litigation, obviously. I mean, the ideal is to say nothing, but if that can't be the case as a practical matter, then it needs to be done consistently.
Yes, I was going to say, I don't know if you can get away with that fully, and we have seen some of these cases play out in the media, whether people want it or not. So certainly when we were talking about specific cases, you look at the Uruguay Philip Morris battle over cigarette packaging rules. That became a very big case that the media really obviously covered extensively. You had Michael Bloomberg getting involved. PMI lost that case eventually. I think in that situation, I'd love to hear from the panel, and especially Jennifer, if you want to start us off, how much of a role do you think the media played there?
I mean, I think I think that the concern as counsel, I mean, one thing we try not to have is that the case actually is litigated in the sense that the argumentation is, the actual merits of the case are argued in front of the press or in the press. And I'm not sure that actually happened on the merits. It was definitely a high-profile case. There's no doubt about it. And it was a situation in which there were a lot of very interested parties, in particular on the product, right? That had high opinions and strong opinions about the product. And that is historical. That's not just limited to this particular case. And I do think, so I think the good thing is it's not something that I think that was on the merits litigated, but definitely it was covered a lot. It became was a very high-profile case. I think because of its high profile, there were a lot of third-party interests that were heard. One of which was the World Health Organization that had given a submission in that, and the tribunal mentioned that submission in their award. So I mean, I do think it had not necessarily a PR campaign per se, but certainly third-party interests that expressed a view. I think may have, at least it was relevant. It wasn't ignored. And of course, you can't say how much of an influence that was on the tribunal's decision or not, but it was definitely a high-profile case. And I have to say that in one instance, I was watching John Oliver, who's a comedian, and all of a sudden he started talking about the case and about the lawyers in the case and put up a picture. And I thought, oh my God, he's going to put up everybody's picture on them. But he didn't. It was actually just some random picture, which was helpful. It was, so it was super high profile. I've never had to my knowledge, there's never been a case that's been a subject matter of a comedian, an investor state case that's been the subject matter of a comedian. But, so yeah, it was absolutely high profile. But I think, like I said, I think that the influence of that was that there were lots of other voices that were heard, and again, I can't say how much influence that would have on the exact outcome of the decision of the tribunal members in the end.
Andres?
Without commenting on that case or any case in particular, I would say that I do not think that cases are won in the media. So when you're asking about the impact of the media on the case, I don't think that cases are won in the media. I think they can be lost in the media for the reason that you were describing. And we have effectively used statements from government officials in arbitration because there's attribution, certainly, and it's probative. It reflects the government's intended course of action when they are very candid about it in a public forum. But in my view, it's two different tracks. We litigate to win cases in court, in arbitration. If we didn't think we were going to win them, we would settle them. But again, our goal is going to be that's not enough. We're going to win the case. It will take years, but we will. But in the meantime, we want to also win in the court of public opinion. Otherwise, that is not a definition of success. It is not enough to be vindicated 6, 7, 8, 9 years afterwards that the company's position was right and the claims and allegations against the company were frivolous. In the meantime, the reputation of the company suffered.
Patrick?
Yeah, and I will say that do as I say, not as I do. My client, the United States, did not forego speaking when it was sued in investor state arbitration. At least a few times it had put out a very anodyne statement that had been vetted by the lawyers. And of course, there were some rogue ambassadors who decided to say what they wanted to say anyway. But it is fraught. I will say that one of the things that is going on in a state's head is, for a very high-profile dispute, is it places the entirety of the system in the court of public opinion, and it kind of very quickly becomes something bigger than just this individual dispute, right? And that really does focus the mind of policymakers who have bought into this system and want it to succeed. So in other words, they feel very personally affronted by how could you put our country at risk in this way, right? By that kind of assault. And that creates a certain kind of irrationality with regard to the statements that you see. So it's very important, if you are representing a state, to do the pedagogy of what this is and what the system is and in advance, so that they have the tools to understand the critiques as they come in, so that you don't get statements that are not helpful for the case, but also born out of a sense of defensiveness over the system. And you know, one of the things that I was able to use when I was in-house in the government, and counsel can use when they're representing states, is use your media plan as a way to educate and get before decision makers that you wouldn't otherwise be able to get in front of. And those empowered to speak for states publicly tend to be relatively high up in the chain. And if you're briefing them on media exposure, which almost always you would be permitted to do, you can use that as a way of educating them on the state and the law, which then can restrain them going forward. So it's a real teaching moment sometimes too.
Tom.
You know, it has occurred to me, Patrick's absolutely right. There is a silver lining to the states talking and talking a lot. And these days, you know, we have 24/7 media. Reporters are everywhere. They're calling, they're reaching out. The silver lining is that the state is not a unified entity. There are many different ministries and different departments with completely different views. And there's nothing more effective for an investor is when another part of the state, another part of the government says, oh, that claim by the other ministry, that's rubbish. There's no law that supports that. We could never be as effective in rebutting those claims as another government official doing that for us.
This is a question for all of you. I think, you know, when we look at this area of the law, it's so opaque, especially coming from the journalist perspective. Do you think that the public has a right to know about these cases?
So it's a complicated issue. I think generally speaking, the public has a right to know about significant cases of national importance that impact the state's financial health. On the other hand, you know, these cases tend to be extremely complicated. One state will change the accounting rules behind investment tax credits so that it can get a vastly larger portion of the benefits from production sharing contracts. It's going to be largely incomprehensible to the public, and when these types of cases are tried at ICSID or other transparent institutions, the public doesn't show up. There's no real interest from the public. There are a few NGOs that may have particular agendas, but unfortunately the public is largely captive to the media that it consumes from the government sources.
Mm-hmm. Mm-hmm. Patrick, did you want to say something?
Well, just, I mean, when you're dealing with matters of public monies, there's almost no way for the state to take a position that it should be non-transparent. At least that has been the driving force over the last, 10 years or so, as we've seen the transparency rules very broaden in scope, and the ICSID amendments bear this out. But even back to 2004, when the first transparency initiatives happened, they were tribunal created before the institutions even responded to them, because the states and the litigants, to some extent, saw that this is a necessity. So I'll say that, but I'll also echo Tom's point, which is the right one, is there's really very little cost to the kinds of transparency that we're talking about. Like ICSID, for example, has a tremendous facility to stream these hearings on the web. And I was terrified the first time that I appeared on the web, thinking, all of you would be watching. That was very naive. One friend emailed me saying, "Oh, your tie looks awful," and then everything else, it was like 3,000 bots from China looking at that from an IPA. No one else was paying attention. So I think the bigger thing would be we don't know what's going on. So I think the costs are low.
Mm-hmm.
Jennifer.
Yeah, I do think, for the very reasons that Patrick was just saying. I mean, these are investor state cases. So when the state is involved, and when high amounts of money are at stake, I mean, I think the population has to understand that this is what's going on. How in detail of information they need to know is another question as to the level of detail. But the fact of the case, I mean, I think that is important, because if the state loses, they're going to have to spend money, which is going to be the money from the population. So, I mean, I think it does make sense to at least make that known. Again, the issue is how far and how much detail do you need, but I think it is important for the state, because it is state coffers that are at stake.
Mm-hmm. That makes sense. So we've talked a little bit about preparing media plans, essentially. And it sounds like even though you take a different approach, each of you, with engaging with the media, that you all have robust media plans in place. So how do you go about crafting that? Or, what are the steps that go into who all is involved in crafting that media plan? And, even if you're ultimately a no comment, what does that look like, essentially?
This is an area where it's easy to get it wrong. So it requires a lot of attention and work, and it needs to be work that's done ahead of time. The media is interested in cases when there's big inflection points, meaning important filings, important decisions, rulings, awards. That's exactly when the legal team is focused on something else, doing legal work, as it should be. Therefore, all the work needs to be done ahead of time, cooperating with media and communications professionals, developing and crafting good, solid talking points that can withstand the test of time, and that allow them to do their work when the inflection point is reached, and engage with the media appropriately. It requires first identifying what the objectives are going to be, depending on what the inflection point is and the issue is. The objective can be as simple as ensuring that a 2-sentence quote gets included with the company, stating the company position very succinctly in all of the key media publication and business publications. It depends on who your target audience is and what it is that you're trying to achieve. It can be much more ambitious than that, and it can be trying to create media attention, or deflect media attention, depending on what the situation, or directing the attention to the right issues to avoid that noise and distractions, divert the attention from the true issues at hand. Well, and one that strategy is defined, then deciding how it's going to be implemented, what platforms are going to be at stake, and how the message is going to be crafted to that platform. Today, it's not enough to be worrying only about the wire. Of course, the wire is important, because if something hits the wire, it's going to be translated into several languages, and you'll have dozens of stories around the world within the next 24 hours. But you cannot overlook social media and all the variety of platforms in social media, how you're going to respond to that, and what are going to be the messages, and tailor the messages to each of the platforms because of the limitations, ensuring consistency across platforms and consistency with, of course, court filings and your legal positions. So it does take a lot of work. It also requires ensuring that the client is fully aligned and understand the downside risk of the strategy and manage expectations. Inevitably, there's going to be a journalist, not your case, of course, but others, who will have an agenda and who will make mistakes, quotes that are inaccurate or misattributed, or get facts wrong, or handle pieces in a way that you perceive as being unfair. All of that said, contrary to what Tom was saying, in my view, that work and those risks are preferable than the alternative, which is that you're ceding that space to opponents who might not be bound by, as I said, the facts, the law, the evidence, and maybe making inflammatory allegations against the company that are going to be unresponded and unrebutted, and then you have to be on the defense dealing with an avalanche of negative misinformation that will take much more time to address.
I agree with everything Andres said. It's actually a lot of work as you're preparing your answer to the notice of arbitration or preparing your notice. You're also forced to sit down with your public and government affairs professionals, your media professionals, and go through all of the facts, all of the allegations, and build very carefully, sometimes wordsmithing, our responses to all of the allegations, trying to make sure that we can fully tell our story in a transparent but also comprehensible way, because we're not going to be talking, if we are talking publicly, just to a bunch of subject matter arbitration experts or engineers, but to the public. So it takes a lot of time, and then it is particularly frustrating having invested all of that time when ultimately when we wind up pushing on our media colleagues to say, okay, so this has been reporting such and such a way, can we push back? Generally speaking, the answer always winds up no. We do put in the effort, and very often don't get to see the fruits of those labors. One additional point, having lived many large disputes, I do find that very often when you actually read the press reporting, sometimes completely neutral or intentionally neutral reporting, the stories are not being reported completely accurately simply because of lack of knowledge or misunderstandings. And so as lawyers involved in these disputes, we're always itching to get this thing corrected, get it right, try to get the story out. So it's very frustrating for us to see these errors being reported and not being corrected. One way we sometimes go about this is we encourage local actors, things like the local Chamber of Commerce, to come out and speak publicly and try to correct some of those errors and misperceptions. We find that's vastly more effective than having the foreign company speak.
And,
Jennifer?
Yeah, no, I was just going to say that even if your strategy is to say nothing, which is often what we're advising, even if the strategy, at least as far as the lawyers go, even if the company wants to say something or the government wants to say something independently, if we as lawyers don't want to be responding to inquiries from the press, it still takes time and effort to manage that, because as I learned from experience, that even if you try to say, I have nothing to say, that can be construed in a way that is portrayed in the report, which is suggesting that you had a view on that, as opposed to one time I answered the phone and I was just trying to be polite and get off the phone, so I said, and I wanted to say, I have no comment, meaning I'm not voicing any opinion whatsoever on this whatsoever, and
Playing dead,
and
yes.
didn't want to be
Neutral.
rude to the person who was on the other line, but they, the way they reported that was, my client had no comment. I mean, it was something more extreme than that. It was something that suggested I had made a judgment call that was not what I was doing. I was completely neutral. So that's what my intent was. But I don't speak media. And so as a consequence of that, I've reached out to, we have people in our firm who are media specialists, who are former journalists, who do speak media. And so I now refer journalists to them if the policy and the practice for that particular matter is to not speak to the media on the issue, because I apparently can't say it in the way that it's understood. So there's a whole different world that that's not my language and it's not my world. So I don't know, but when I was communicating this situation to our media people, they said, yeah, well, the way you said that was indicating something, and that's why they said it the way they did. And I have no idea what you're talking about, but please, you respond. And so that's, in the future, that's what I do. If it's something that we can't, or we decided strategically not to address on our own, then I will give it to a professional dealing with media who know how to address it in a way that's not rude. I mean, I don't want to be rude. I didn't want to be rude. I was just a human being trying to politely say, I'm not going to talk to you.
Yes.
But by doing that, that had an implication which it did not intend whatsoever. So
It's easy to do, and journalists are grasping for straws in some of these moments, so looking for anything.
didn't say that.
Patrick.
Just a quick point on, I guess this is my theme, that not all media are the same either. And when you're looking at, when we're talking about speaking to the media, there's a difference between speaking to a national paper like the New York Times or the Washington Post, or speaking to a quote-unquote reporter from a blog or something that is not as consistently ethical, perhaps, as some of the other more mainstream paper. And by the way, I'm speaking in my personal capacity. Nothing I should be said is attributable. But I mean, there's a difference. So, some of those signposts that Jennifer was talking about matter to certain press outlets and not to others. So when you say off the record or this is on background, those signposts mean something to some and don't mean something to others. So states and clients need to be very careful about that. And I think that the point that Tom made is very well taken, and states do this a lot, is they find validators, what we call validators, in the marketplace to get that story out on their behalf. So if it's a case about an environmental regulation and there's an NGO that's been involved in those issues, oftentimes that NGO will be the one to bring the story that the state would otherwise want to tell, right? But it's important, of course, for the state not to hug those validators too closely, because, of course, they don't speak for the state and they have different agendas too. So I just wanted to say that one of the complexities in this world is, Twitter and everything else is now a media outlet, and that's just not, what it used to be.
Right, Twitter's a major media outlet. That's where a lot of news is broken at this point. So we've talked a lot about how each of you kind of views this in your respective roles, but I'd be curious to know how the different tribunals have reacted to the media and public outreach, and does that affect the way that you approach these cases at all? Or, have they taken specific stands that kind of make you change course, I guess is the question. Tom.
My sense is that it doesn't affect the decision-making at all. What it does affect is that tribunals are increasingly aware and assume that their public international law investor state awards are going to become public, whether properly public by consent of the parties or the institution, or simply leaked by somebody. And so I think my sense is that tribunals these days tend to approach award drafting very carefully. The awards get even longer, even more detailed, so that when they do become public, they appear as legitimate and well-reasoned and well-crafted as possible, and are beyond approach. But I don't think there would be any difference in terms of actual substantive decision-making between a confidential ICC award and a public ICSID award.
That makes sense. And then, you, Tom, I think you alluded to there are times when you've seen things that you would have loved to respond to. So for all of you, are there times when, again, you wish that you could have taken a more proactive communications approach or set the record straight somehow, but were constrained from doing so by the arbitration rules or the instrument of consent, things like that?
I'm not sure it's a matter of arbitration rules or the instrument of consent. Mostly it's an issue of strategy. If you think, and most investors are risk takers and optimists, that there is a way to resolve this, that not everything is lost, that by engaging quietly with the government and making targeted concessions, this investment can be salvaged, then you want to avoid a public mud fight at all costs. And even though I travel around the world, and sometimes it's happened to me within the past year, I land and the main local daily has a front page story of, state goes to court against oil companies to recover what is due, and it completely misrepresents the situation. We just have to bite our tongue and not say anything and hope things get resolved.
Jennifer?
Yeah, I mean, I would say there are definitely situations. And so as a general matter, I think our advice and tactic is to not litigate the issue in the press. So not necessarily engage in the press, although, if the client wants to do that because for strategic reasons, they think that's important, I think that's totally appropriate. But as a lawyer representing the party, that's not necessarily the role that we take. But it's certainly the situation where you might get in a situation where the other side, I think this is exactly where Andres is coming from, where the other side is engaging, they don't have that strategy, and they are not only raising issues in the press, but raising issues that are not correct. They're just not correct. It's not a matter of this is their perspective and their arguments that they're raising, but they're actually saying things that are factually wrong. And yes, that your compulsion, of course, is that you want to correct that record because it's factually inaccurate entirely. And I think if it's in a limited period of time, and I've had at least one situation where it's very much like that. I really wanted to engage, but restrained from doing so. I think if it's for a limited period of time, you can manage it in that way by not engaging. Because you don't have full control over how the press will report. So I think that's the danger in engaging in that way. But if it's a short-term situation, I think you can manage it that way. I'm not sure if it's a long-term situation that Andres is discussing, that it is advisable to do that. But if you can do it in a short term, you're hoping that it's not going to be influential. In the particular matter I'm thinking of, it was an issue that was before U.S. District Court at that point in time, and I was hoping that the judge wasn't paying. It was in trade press. I was hoping the judge wasn't paying as much attention as an arbitrator probably would, because that's the media that is everyone's focus. But a judge in the U.S. may not. So in the end, the ruling. He saw through, saw the light and saw what the actual facts were, which I was very glad about. But there is definitely an interest in wanting to engage, but there is a hesitation because you don't know if it'll be an actual fruitful exercise, and chances are probably not, and best be litigated in arbitration itself, in the confines of arbitration itself. But unless I think if it's going on for a long period of time, in which that becomes more of an exception.
Patrick.
Sure, just very quickly. In my experience, there hasn't been a lot of success in the ability to correct the record. You're often most concerned about specifics and nuance that just don't make it into a press story, and trying to correct the record often does more harm than good. But I do think from again, a state perspective or a sophisticated investor's perspective that's trying to resolve this dispute or at least preserve their reputation, there are more targeted ways to get your story out there and to get it corrected to specific audiences. So if you're a state that is primarily a capital importing state and you're concerned that the investor of a home country is spreading misinformation, you are a state. You can contact that state directly and engage at a political level, which is protected generally, in a kind of one-on-one, state-to-state dialogue, right? Which will potentially be beneficial to you in the long run. Same if you are a state with a lot of foreign direct investment in a certain sector. You can reach out to your investors proactively and say, I know you've heard this in the news, but here's some things that you don't perhaps know, right? And you need to do that smart, because that's not necessarily a privileged conversation, but there are ways to do that. And similarly with an investor, right? You can use surrogates, you can engage very targeted on audiences that are not media, and then trickle the story out that way. And that's oftentimes more effective than just giving a quote or speaking on background.
Andres.
So I would say that without litigating the case in the media, which is something we wouldn't do, correcting the record, we would take all steps necessary to correct the record if there's false allegation being levied publicly. And there's a variety of means to do that. If you are not being successful with mainstream media, there is just today no shortage of platforms that you can use, everything from creating your own website with a repository of information, creating your own videos with information about the case, presented shortly and in a visually appealing way, using Twitter, using social media to try to get the message out and respond to false allegations that should not be allowed to stand unrebutted. Rather than simply staying silent, adopting the no comment approach, which implies that you have doubts, can be interpreted as you have doubts as to the merits and strength of your case.
Mm-hmm. Yes, Tom.
I wanted to comment on something Patrick said. It's very important to talk to the state in any major investor-state dispute, and there are extensive discussions with the state in almost every case. But you also have to be aware that states are actually terrible leakers. Sometimes they're leakers deliberately because they have an agenda behind the leak. Sometimes it's just because it's their nature. There are so many people involved, and everyone wants to be able to talk to the media and sound important and leak a part of the story. And so in the concept of trying to address things with the state, you have to be extremely careful what you tell the state, because you might find yourself in a situation where some of the most confidential discussions are on the front page of the papers the following day. And it's happened to me where the papers report suddenly that the investor consortium has actually offered a settlement of X million dollars for this very legitimate state gripe, even though we felt that there was no legal basis for the claim. We just wanted to to make a good faith offer to see if we could make it go away.
I feel like I haven't really made the case for talking to journalists in this panel. So I will say that by the time a reporter usually calls you, we're going to write the story. So I think a lot of times what could be helpful is that if you're even willing to talk to us on background, because I think this is such a complex area that I think any good journalist doesn't want to get it wrong. The best thing you can do, obviously, is, once a decision has been made, send us the actual decision, because I think, having that primary source is the easiest way to make sure that you get it right. I understand there are a lot of restraints in this area, but I do think that, most journalists are going to keep going and pursue it, and you can help yourself a lot if you're willing to engage to even that extent of saying, I can't really give you anything on the record, but let me kind of talk you through the big points here. So.
And because you are the only one in the panel who is a journalist, share with us what you see from us, from the legal community, that we do wrong, that you're surprised that we don't get better at, things that work, that make your life easier and your work easier, and the story more accurate. What would you define as the best practices and mistakes that we tend to make and we should be avoiding?
Mm-hmm. Well, I actually think just what I mentioned, that's probably the key for us. I think even being willing to talk on background to us, because the other thing is that journalists have to verify. So if we have nothing to go on, then it's very difficult for us to verify what you're telling us or anything like that. And I think if it is a big win, obviously we can be your best friend in that situation, because we're going to give you publicity in that kind of case. So, but I would say, Jennifer, I was horrified by your story, because it's probably so easy to have your words misconstrued that way. And I don't think that's anyone's intention. But I think, again, even doing more conversations with journalists or coffees with journalists, I think can also help, because especially we have a lot of young journalists at Law 360, I know, who, when they're diving into some of these questions and issues and areas, obviously they don't have the years of experience that you all have, or understand the nuances involved. So I think any kind of leading that you can do that can only pay dividends later on, especially when you have a case.
So let me ask you this question. How do we know that when one says that they'll discuss something on background, that will actually be honored? I mean, how is it just a matter of knowing the people you're speaking with, the journalists, and being able to make that judgment call, or is there any advice you would give? I mean, I agree that it makes sense to you can help and inform, and therefore make a potentially better product in the end, right? As far as the story goes, but how do we know? How we know who and what level we can trust what is going to be said?
That's a fair question. I think I understand that there's a lot of skepticism because I think, Patrick, to your point, different media outlets have very different views. I think you can really clarify that at the beginning of the interview with the reporter. You can say, okay, let's set the ground rules, because most reporters want to talk, so they'll play by your rules generally if you're playing fair. So I would say some of it is getting to know the reporter and the organization and kind of establishing a level of trust. But I also think you are well within your rights as the person being interviewed to say, this is what I'm comfortable with. Quote checks are a big thing, obviously, things like that. So I think any of that can go a long way. Tom?
So my partial response to the issue raised of the story will get written, I think it's in the public interest to get it right, is when I can't comment, but there's something out there that's already public, then I'll say, but have you seen X? Or sometimes if there's somebody who's speaking to the subject in a knowledgeable way, I'll say, I'm sorry, I can't comment. But before you write the story, you should talk to so-and-so at such and such an institution or at the Chamber of Commerce who may be able to help you.
And that's very helpful. I think the worst for a reporter is just being this wall or this dead end, because again, they've got a job to do too. Andres, did you want to say anything?
So what is your advice when dealing with journalists that are just parroting uncritically inflammatory allegations without any basis on evidence?
I don't know any of those, so. No, I mean, I think it has to be a judgment call ultimately. Whether, you feel like it is in your interest, your client's interest, your company's interest, the state's interest to engage. But I think, there are plenty of times that you should probably just say no comment. So. Or nothing.
Should we crowdsource this and see if there's anything?
I think we have about 5 minutes left, so if there are any questions, feel free to go to the center of the room, and we'll go from there.
Yes, thank you, Eloise Obadia. You talked mainly about communications with respect to a dispute, okay? I wanted to ask two questions on a broader level. One is, what do you think of, and here I'm talking more about specific arbitration, media, and what do you think about some law firms or individuals who are using those media as a marketing tool? So that's a broader question. The second question is, we see a lot of, we see some reports, documentaries against ISDS. Do you think as a community we should think more about having an overall communication strategy to actually produce something more balanced and more fair, like reports? Because what we see, I have an example of a French documentary called Envoyé Spécial, which was so biased. I'm sorry. Some aspects were maybe correct, but others were biased against ISDS. So we see a lot of communications against ISDS. So don't we have a role to play to give a more balanced vision of ISDS? All right, thank you.
Lawyers using legal media as a marketing tool? I'm shocked.
Who wants to answer that? Anyone?
Well, Louise, I think you may be assuming that we are not speaking on the issue of ISDS. I think everybody is, to the extent through various organizations and chambers of commerce and associations, is in, I would say, a desperate fight to protect ISDS rights, because we understand, and particularly as investors, how incredibly valuable they are and how much they are threatened. Frankly, an investment court appointed and reappointed every few years by the respondents is not going to be terribly persuasive to us as a neutral finder of fact. So I think we have an obligation to speak up if we're going to defend the system, and to my knowledge, a lot of people are doing that.
Okay.
Patrick?
Thank you.
Thank you.
I will give a couple of suggestions on how to proceed. Normally, if someone calls me up on a client matter, I'm guided by the client, and the client say, do you want to fight in the media or do you want to do it in the courtroom? And I always say I want to do it in the courtroom. But people will call you up with technical expertise questions. So there are a couple of things that you should bear in mind. One, return the phone call promptly, because everybody's working on a deadline. Two, if you don't know, you can say, I don't know. Three, you start off the conversation by saying, these are the rules, this is on background, or you can use this as a quote. The worst thing in the world you can do is to try and say, oh, I've been talking for 10 minutes and I'd like to put that on background now, because that doesn't work. You will eventually develop a relationship with someone and you will become their go-to person when they've got questions of X. So the comments I make as counsel of record are different than the comments I make as an elected official when I do have a lot of comments. And the press has my cell phone number and they will call, and you do call them back, and you basically have to give them a quote. And you try and make sure it's an interesting and informed quote, and then they'll usually call you back and say, just want to make sure I have it right, and they'll run it by you, and that's perfectly fine. But you have to remember that those are two different sorts of things. And if your client wants you to comment in the press, mazel tov, I'll comment in the press. But you have another function, like the previous person said, to respond to the press on background. And if they want to put you in front of a camera, you can decide whether or not you want to go. But as you say, you've got a job. Lay the rules out carefully, and you're going to make mistakes, but be succinct, call back promptly.
I don't know. I mean, in the last minute, I'll just say that, for me, practicing in this field is a privilege because it involves public international law. I never wanted to be a media personality or speak to the press. It's, I think, an awkward position to place lawyers in. Obviously, sometimes we are called upon by our clients to do so for any number of smart reasons. But generally, I think most of us are uncomfortable with that position, and if a lawyer is put in that position, I think it needs to be for a pretty limited function. Generally, it should be from the client, with the lawyer standing very close in the background. But as lawyers, I always want to be the person behind the person in the green table, right, with the microphone in front of them, never at it, unless called upon to do so.
Of course. Okay, I think we'll let that be the last word. Thank you all so much for your attention, and thank you most of all to our panelists.